Welcome back to Live Now from Fox. And this is a live look of the Supreme Court as the justices have now ended hearing the oral arguments in the case of former Trump's immunity case, and they will now decide whether a former president is immune from federal prosecution for official acts. This comes, of course, after justices heard arguments from both Trump's attorney and the attorney for the special counsel on this very issue. Should a president be immune from federal prosecution for official acts? And again, we just heard nearly 3 hours of arguments as justices questioned both Trump's attorney, John Sauer, and the attorney for special counsel, Michael Dreeben. And again, we do not know exactly when the justices will hand down their decision, but that is what they are doing right now. Trump is the first former president to face criminal charges, making his appeal the first time in the country's history that the Supreme Court has had occasion to weigh in on this case. I do want to bring in Brian Claypool, who is a criminal defense attorney. Brian, thank you so much for taking the time to join us.
Sure, great to be with you. I mean, we're all seeing history in the making.
Absolutely. And you were listening along with us as we were hearing arguments from both sides, both Trump's attorney and the attorney for the special counsel. Of course, there are enormous implications in this historic case. Can you break down what those implications could be?
Yeah, sure. I mean, at the end, you heard one of the justices outline it. There are two competing interests here. One is if there is blanket immunity, there is a fear that presidents in office will be boundless. What does that mean? They can do whatever they want. They can break the law and not be held accountable. That's in layman's terms what the first competing concern is. The second then competing concern is prosecutorial misconduct. In other words, the DOJ bringing charges against presidents when they leave the office that are politically motivated, right? And those are two really competing interests, and both should be addressed, right? In fact, one of the justices just suggested that if there's a determination that charges are brought against a former president that are politically motivated, that there are consequences for bringing those charges, that somebody's going to be removed from office because of that. So with that said, I really think what the U.S. Supreme Court is going to do is that they are not going to agree on just blanket immunity for a former president. I think what they're going to do is this is going to boil down to was the conduct an official act? You mentioned that a couple of minutes ago. It all boils down to, is the conduct an official act? And it was interesting because they were actually talking about breaking down each allegation in the current indictment, right, to see whether that would be deemed an official act, or is it a private act? Is it an election seeker act, right? So with that said, I think what the court's going to do is remand this matter back to the trial court, to the U.S. District Court, and come up with some formula to decide whether each of the acts alleged constitutes an official act. And if it's deemed an official act, then there's likely to be immunity, right? There's going to be immunity for the official act. But if it's deemed a private act, an election seeker act, then there's not likely to be immunity for that. So the big question then becomes, how mechanically, how procedurally do you reach that determination if it's sent back to the U.S. District Court? We heard a discussion about, is this a fact issue for the jury, right? That was an interesting discussion. Does a jury decide whether each allegation is an official act or a private act, right? Or is this a determination that is to be made by a U.S. district judge? And then another interesting issue is, then there would then be what's called an interlocutory appeal. That was discussed. What does that mean? Well, in most cases, you have to wait till the end of the case to go for an appeal, right? To appeal a decision. I think what the U.S. Supreme Court's going to do here is say, we've got to figure out a way to determine official act versus private act. And then based on that determination, each party will have a right to an immediate appeal of that decision. and then it may very well end up then back at the U.S. Supreme Court.
Which is so interesting because, again, the arguments that were laid out today, it was, as you mentioned, a blanket, right, over what constitutes immunity, what constitutes an official act, and it wasn't outlined. So if the judges decide to hand it back down to a lower court, would you imagine that that would happen fairly quickly? Or do you imagine that this would be weeks before they come to that decision, if that's the decision they come to?
Yeah, great question. This is a really complicated matter, right? I mean, this argument went on, over 3 hours? I do not expect an immediate ruling on this. I think it's going to take weeks, if not until sometime into June or before the U.S. Supreme Court adjourns in early July. Why do I feel like that? Because of what we're talking about. Think about it. You've got to have all these justices. We have to have a majority decide that there's no blanket immunity, right? And I really think that will be the determination. But then you've got to think about that formula we talked about, right? If it's sent back to a trial court, here, the DC trial court, what is that formula then for determining the threshold $1 million question? Is the conduct an official act? Again, if it's going to be deemed an official act, then there will likely be immunity. But they got to figure out, what's that mechanism? Does a judge decide that, or does a jury decide that? My gut instinct tells me that this should be left more for a legal determination. In other words, a trial judge hearing the evidence on both sides, and then the trial judge determines, is that an official act? Is it a personal act? Is there immunity on this allegation or not immunity on that allegation? And that's going to take some time. That's not a simple formula, and you've got to get a majority on that.
And again, as we were hearing the justices say, this really will set a precedent for future presidents to come, whether or not a former president could be accused of breaking a law, because again, as one of the justices said, every current president will eventually become a former president. And if you're always looking over your shoulder, wondering if your predecessor is then going to accuse you of committing a crime, there is a slippery slope. So again, as you mentioned, this is incredibly nuanced, incredibly complex, and really the first time that such an issue has been brought before the Supreme Court. So as you mentioned, they have a lot to weigh in on. And again, we were almost 3 hours into arguments. You were with us and we were listening in as the justices were questioning the attorneys. When you heard both sides of it, did there appear to be the justices leaning on a certain side? Or again, did we walk away with, we do not know, and likely we will have to send it back to the lower courts for that determination?
Yeah, great question. I think it's hard to tell what the numerical count will be, but if I had to, give my legal, conjecture on what it will be, I do think it's going to be a close decision, but I think maybe it's a 5-4 decision in favor of that there is no blanket immunity, just what we talked about. Remember Justice Elena Kagan, she asked a really profound question. If there was a coup ordered by a president, would that be an official act, or would that be a personal act? And that's really what we're talking about here, right? If a president is doing something that's out of bounds, in other words, it's beyond the scope of what an official act is, shouldn't there be some accountability for that, right? I mean, I think that was a really powerful question. One other big takeaway, a huge takeaway I had from this argument was President Trump's lawyer actually admitted at one point that some of the alleged acts by former President Trump were not official acts, right? That they were actually private acts. That could prove to be, I don't want to say catastrophic, but that would not bode well for President Trump, because that's kind of an admission by his own lawyer, for example, that if the court wants to look at this official act versus a personal act, that his lawyer actually just admitted that there are some acts that were not official acts. So the way I look at this then is, I think eventually you're going to see this going back to a district court judge. And I think you're going to see eventually, many months down the road, that some of the allegations against former President Trump are going to survive and eventually end up going to trial, but more than likely after the election.
And again, that really is the central question now. What constitutes an official act as a president? Do you actually have to say this is an official act that I am, doing as a president, or this is this is for my own personal actions? How does one currently define that?
See, that's such an incredible question. That's the $1 million question, right? And as we sit here today talking about it, there is no precedent on that issue. What do I mean by precedent? There's no other cases determined ever in the history of our country. There's no laws existing, right, that talk about here's what's an official act. Here are some examples of an official act. We have absolutely no template to determine what's an official act. So that's going to have to be created in the coming years, either through a new federal law that's enacted by Congress, right, that might speak to this, or number two, this is going to be developing law in the coming years based on what's called case law. That's where the trial judge rules, is it an official act or not? Then it goes all the way up to the appellate court and then eventually to the Supreme Court. And the Supreme Court might have to eventually decide in the coming years what is an official act. With that said, though, I will tell you that there are certain things that I think it's pretty clear are not official acts. For example, there was just an indictment today in Arizona of several of Trump's advisors and lawyers for acting as fake electors in the Arizona election. And I looked at some of the documents in that case, and if you have people if you have a politician, and by the way, Trump was not indicted in that, right? But I'm just giving you an example that they created a fake document saying that Trump should be entitled to 11 electoral votes, yet he lost the election, that he lost in Arizona in a popular vote. A conduct like that, let's say a president was involved in that to me is clearly not going to be an official act, right? That's an election act. That's an elector trying to be seeking office. So I think you're going to find some conduct like the coup, right? We talked about Elena Kagan. If a president orders a coup, I think that's clearly going to be not an official act. But your question raises a great area of concern, which is what happens in the gray area, right? And I think that we're not going to get an immediate answer on that. That's going to take, again, either years of courts interpreting that or some kind of federal law that kind of clarifies what official acts are and what they aren't.
And again, we have not yet, and as you mentioned, this really sets a precedent. There is no official definition of what an official act is. But when it comes to elections now and people seeking office or future presidents, how might that play into how they act with this potential possibility of then being criminally charged down the line?
Look, another great question. I think there is a lot of utility, a lot of social utility in this hearing this morning or this afternoon. I'm on LA time. But look, regardless of the outcome of this, I think the U.S. Supreme Court made a loud statement today to any politician who wants to try to interfere with election results that they are likely to have to face the consequences for that. That's my prediction. And let's say I'm even wrong. I think the tenor of this discussion today was so impressive, right? The back and forth, the thoughtfulness of these justices, the preparation they had, the concerns they had, right, about prosecutorial misconduct. I think this discussion today is going to make any politician, president, or anyone seeking office, they will now think twice, right, before they engage in any conduct that defies what the voters have voted on in this country.
They also kept bringing up Nixon, of course, as the primary example of some of these concerns. From your legal perspective, why has a case such as this never come before the Supreme Court? Why is it happening now?
Yeah, I mean, just so your viewers and listeners know, the Nixon case was that involved a civil the immunity on that case involved a civil defamation lawsuit, and what lawyers were arguing for the prosecutors were they were saying that it doesn't apply to a criminal case, right? That a criminal case is different. Civil cases deal with monetary compensation. Criminal is much different. It's if you break the law, you have to pay the consequences for that. So that's one distinction. But getting back to your question, I think wasn't Nixon I think he was pardoned, so we never saw this issue of the first sitting or former president being criminally charged. I mean, that's why you and I are having this discussion. This is the first time in the history of the country that a former or sitting president has ever been charged or indicted with a criminal act. And now we have to determine a massive question. Should that president face prosecution in a court of law, or will this spiral into presidents not being able to do their job effectively because they are now going to be worried about being prosecuted in federal courts?
And Brian, I do want to share this with our viewers because this is a statement from former President Trump on the immunity case. He writes, quote, "If a president doesn't have immunity, she will be nothing more than a ceremonial president, rarely having the courage to do what has to be done for our country. This is not what the founders had in mind. Protect presidential immunity, make America great again." You know, he brings up a point that if the president doesn't have immunity, then again, he'll just be a ceremonial president. What do you make of that statement right there?
Yeah, I'm not sure I agree with former President Trump's statement, and here's why. I think it's clear under the law that discretionary acts, right? We've been talking about this. What's an official act? An official act is going to be deemed what's called a discretionary act, where a president has to make a decision. Do I send troops to Ukraine or not, right? And some of our troops are killed in Ukraine. If that happened, that is a discretionary act that's clearly going to be construed as an official act as a president, and a president's not going to be prosecuted for that. So I'm not sure I agree with this, that a president can't get his or her job done now, and they're just going to be ceremonial because they're going to be facing prosecution for anything. That's not what this discussion is about. This is about a president, a former president, who allegedly takes matters into his or her own hands on an election and does something that arguably interferes with the election results. That is not the type of conduct, if it's proven to be true in a court of law, that is contemplated by a president who is acting within the scope of doing his or her duties. So I respectfully disagree that unless there's blanket immunity, a president can't get their job done. Think about our history, right? I think we've seen presidents for the last 100+ years get the job done and not have to contend with any criminal prosecution.
Meanwhile, former President Trump, he is currently inside a New York City courtroom for another trial, his hush money trial. I'm wondering, obviously, there's no decision being made today in regards to the immunity case, but how does what happened today impact, if at all, Trump's other cases that are currently open?
Well, that's a good question, because with other pending criminal cases against President Trump, I mean, this case, the hush money case is already in progress, right? So we're not likely to get a U.S. Supreme Court decision, my prediction, within the next 2 or 3 weeks. And if I'm right on my prediction, then there's going to likely be a verdict in the hush money case, right? One way or the other. But that said, as to the other cases pending, the Georgia case, you've got the classified document case in Florida, those could be affected, right, by the U.S. Supreme Court's ruling. If they rule as I think they will and say, send this back to the district court, let's determine what's an official act and not in the context of the indictment, then I think you're likely to see that happen in the other two cases. In other words, I think those courts are going to have to make preliminary determinations as to what conduct is an official act and what is not before those cases actually proceed to trial. And what's the impact of that? Then it's not likely that either the Georgia case or the Florida case ever sees a courtroom before any time next year.
And again, I would have to imagine that right now attorneys for both Trump and the prosecutors could then tailor their arguments to argue that it was not an official act or it was, to get ahead of what that potential definition is.
I'm sure they will, but they're not going to define what the law is, right? I think, like I said, eventually people have to understand that law is not magically made, right? It's like when I'm researching my cases, sometimes I'm looking back at cases from the 1970s, right? It's not some magical formula where you click your finger or wiggle your nose and we've got a clear definition of what's an official act. And lawyers can postulate all they want as to, oh, this is an official act, this is not an official act. We saw it going on right in these arguments today, but they're not the ultimate arbiters as to what is an official act or not. That's going to be determined, I think, in the coming years. My prediction will be by judges. I don't think juries should be making decisions on what's an official act or not. And here's the reason why, because then it's going to create a ton of inconsistency, right, across the country. You're going to have one jury ruling this way on an official act. Another state, there could be a prosecution. They could argue another way. I think we need to have judges making those decisions. And then, remember what we talked about before, then there's going to be an appeal. And by the way, back to your other question, that could delay the other cases for even longer if either side does what's called the interlocutory appeal. But I think the best way to do it is to have a judge determine it. Then there's an appeal, and then the U.S. Supreme Court might end up being the ultimate decider on what's an official act and what's not an official act. But that said, this could take many years to get a more distinct, verdict on what is an official act and what isn't.
Just listening to the arguments and the question and answers was truly fascinating. Again, this really has never been a question that has been brought before a court today. Brian, before we let you go, is there anything else that really stuck out to you, or anything that you're really looking for in the coming weeks and months and possibly even years?
Yeah, I think we've talked a little bit about it. I think we really need some guidance from the U.S. Supreme Court, unlike you just mentioned too, on what actually is an official act, right? That's what really strikes me the most here. Is the good news is this: I feel good about the fact that I think the U.S. Supreme Court justices are on the right track. That we need to clarify, right, what really is an official act and what isn't. That's the good news. So there's not likely to be a blanket immunity. But I think the challenge ahead is going to be who's going to determine, right, what is an official act, what is it, what isn't, and then how is that going to be interpreted by appellate courts across the country if this happens again, and then ultimately the U.S. Supreme Court. So that's my takeaway: is it could take quite a while before we really get some clarity on this. And that frustrates a lot of people, but I've been a trial lawyer for many years, and that's a part of our practice that a lot of people don't really understand, that sometimes there not is always clarity, right, on what the law is.
And again, one cannot rush this process. As you mentioned, the precedent that will follow is incredible. So a lot of thoughtfulness, I'm sure, will be put into this. Brian Claypool, criminal defense attorney, thank you so much for taking the time to share in this conversation. It is absolutely fascinating and historic. So we appreciate you being here on Live Now from Fox.
Yeah, I appreciate your time. Thank you so much.